contact the alleged victim. Counsel, what do you have?
In this matter, the officer had entered into the house after just hearing somebody crying inside, and they opened up the door, and that's not enough for to justify any sort of exigent circumstance to enter the.
That's good defense, counsel, if it's, if you can prove it. But the problem I have is it's not a defensive to the, my issue here is probable cause in terms of release. So it's $500 bond, but no contact with the alleged victim.
Your Honor, we would be requesting ROI because she doesn't have the monetary ability to post the bond.
Court, we'll leave it at 500 right now. Now we have Samantha Lloyd.
She's right here, Judge. That's it.
Samantha Lloyd, you're charged with domestic battery by strangulation. The court finds probable cause. Bond is set in the amount of $1,000. No contact with the alleged victim.
Thank you.
We have Shauna Hudson.
She's approaching now.
We have a aggravated battery causing bodily harm or disability. Court finds probable cause. Bond is set in the amount of $2,500. No contact with the alleged victim.
Your Honor, we would be requesting an ROR. She does have a separate address to live from the alleged victim in this case.
Denied at this time. Susie Santos. Susley, I'm sorry. Santos.
He's approaching now.
Ms. Santos, you're charged with DUI, $500 bond, and some traffic infraction. Court finds probable cause. Can you make the $500?
She can, Judge.
Okay.
Your Honor,
Post bond.
on this matter, I'd like to make a probable cause.
Go ahead.
In the initial approach, there was only an odor of alcohol, and the
Counsel?
the cop says that she had simple, she couldn't understand simple instructions. It was later found in there that she spoke Spanish, so that describes why.
Counsel, I absolutely agree that you could make that argument when you file the motion, but those are defenses. And this is a probable cause affidavit to determine whether, if you're questioning the stop, that's a motion to suppress. Okay, thank you, counsel. Okay, now we have Alvanka White.
She's approaching now.
Ms. White, you're charged with battery, $1,000 bond. The court finds probable cause. Have a good day.
And Your Honor, at this time, she doesn't have the ability to post a monetary bond, so we would be requesting a ROR or the alternative, some form of pretrial release.
Well, counsel, I think the $1,000 bond is quite reasonable under the facts of the case.
Understood, Judge.
Felicia Coffey.
Medical reset, Your Honor.
Thank you. Thelma Flint. Ms. Flint, you have a driving with a suspended driver's license felony, $750 bond. Court finds probable cause, and then you have 2 no bond holds. They appear to be out of St. Lucie County. Court finds probable cause. You'll be detained pending your transfer to St. Lucie County. But you're going to have to dispose of the driving while suspended first. Have a good day. And we have Christina Vecchio.
Medical reset. Medical reset, Your Honor.
Medical reset, thank you. Jolene Hernandez.
She's approaching.
Ms. Hernandez, you're charged with, you got a misdemeanor capias. The problem is that's count 1. with a $500 bond, but you've got 2 felony VOPs, no bond hold by Judge Weeks. You'll be detained going before Judge Weeks on the no bond hold. Court finds probable cause, all counts. Okay, then we have Gladys Salazar. Ms. Salazar, you have an out of county hold from St. Lucie County, and it's a no bond. You'll be detained, being transferred to St. Lucie County. If you have no matters holding you in Broward County, you're ordered to transfer to St. Lucie County forthwith. Have a good day. Then we have Marva Cooper.
Your Honor, I'd like to make a probable cause.
Okay, we'll give you that in a moment. You have 2 people here on this also. Marva Cooper, you're charged with aggravated assault with a deadly weapon and burglary with assault and battery. Go ahead, State, you want to say something?
Yes, Your Honor. The state is requesting the court to make a finding of proof evident presumption grade on charge 2 of burglary, burglary of assault or burglary of battery. And hold, excuse me, I'm sorry, Judge, and hold Ms. Cooper no bond hold.
Court has reviewed the file and everything that has been presented before the court based upon the facts contained within those documents. The court denies the state's motion.
Your Honor, if that's the case, the state's asking for you to set the bond at $500,000.
I believe that what does the law say on bonds?
Your Honor.
Yeah, what's the law say?
Well, the state is asking you to find proof evident presumption great,
But, well, no, but you don't have a sufficient fact for proof evident presumption great.
Your Honor, may I?
But go right ahead.
Okay, thank you. Based on the PC affidavit, it states that the defendant, Ms. Cooper, without permission, entered into the home of the listed victims without permission, breaking and entering with the intent. She carried a knife with the intent to create harm. The victims feared for their life and their safety and believed that they were going to be stabbed by her.
Next question.
Yes, sir.
Isn't the level of proof for proof evident presumption great beyond it to the exclusion of every reasonable doubt?
That's not.
And doesn't the facts also say that she was kicking on the door and that they opened the door?
They did not invite her.
I didn't ask that, ma'am. I asked that question. Did you leave that out?
No, I did not.
You did not?
No, I did not.
You said you said she broke and entered.
No,
She kicked on the door and they answered the door, didn't they, counsel?
Well, Your Honor, if somebody's kicking at your door, you're trying to figure out what's going on.
But that goes to whether it's beyond and to the exclusion of every reasonable doubt. And the court has denied your motion. Okay.
Also,
Defense?
Your Honor, in the inception, the officer says that it was a neighbor, and then later on they say the unknown neighbor. So how do you know if they're your neighbor, but then how are they an unknown neighbor? You would have known that they're your neighbor before.
I'm not getting into the linguistics of the police report.
And
There are 2 people here indicating stood up that they're in reference to this matter. Do they have anything they want to present, or have you had the opportunity to talk with them?
no, Your Honor.
Why don't you take 30 seconds?
Yes, Your Honor. Hi, Your Honor. I'm here with Mr. Tony Cooper, who was actually present at the scene and said that there was no weapon involved and that there was no.
Counsel, that's again goes to the defense. Okay, I didn't know whether these were possibly Mr. Johnson or Mr. Walks, who were allegedly the people who were in the apartment. Okay, and when the cops, by the way, were referring to the unknown neighbor, they were referring to Mr. Johnson and Mr. Walks not knowing her as being a neighbor. Okay, other than possibly have seen her. Court finds probable cause as to both counts. Court sets bond on the aggravated assault in the amount of $5,000, on the burglary with assault in the amount of $5,000. No contact with the alleged victim, no return to the property.
Thank you, Judge.
Thank you.
And that order is modifiable by the judge to whom the case is assigned. Have a good day.
Your Honor, I mean, this is where Ms. Cooper lives.
I understand that, but I have a problem in that I am setting a bond that I think is quite reasonable in the case. I have found that the incident arises out of a domestic argument she was having with some third party. And that I feel that it rose to the level where there should be no contact, and the individuals who were the alleged victims should not be exposed to it. Now, counsel, if you want something else, you're going to have to talk to the judge to whom the case is assigned.
That's fine.
Then we have Vaughn, Renata Vaughn. This Vaughn, they got an out of state hold, Texas, from Texas, which is no bond. If you do not have any other matter pending locally, you will be taken before the extradition judge. You will have the opportunity to either waive extradition or to fight extradition. They will explain that when you go to the extradition court. If you don't plan on fighting the extradition, if you're going to waive extradition, you may want to do it as soon as possible, because the time limits that the state of Texas has to come and get you or you otherwise be released starts to run when you sign the waiver of extradition. Have a good day, man. Then we have Shinsei Strachan. Okay, Miss S-T-R-A-C-H-A-N, Strachan.
Correct, now, sir.
Okay, Mr. Strachan, you got two out-of-state holds. Both of them are no bonds. They're from the state of Texas, and you will be detained going to the state of Texas for extradition. As I said to that other young lady, if you waive any extradition or plan on waiving extradition, the sooner you do it, the sooner the process starts. And if you're going to fight it, they'll tell you what you have to do when you go to the extradition court, which will be sometime next week. Have a good day, sir. And D'Angelo Brim. Mr. Brim, you have a domestic battery. Court finds probable cause. Bond is set in the amount of $500. No contact with the alleged victims. Then we have Watkins Gene Simon. You're charged with battery. Domestic. Court finds probable cause. Bond is set in the amount of $1,000. No contact with the alleged victim.
Thank you, Judge.
We have Renson Martinez. Mr. Martinez, you're charged with
Your Honor,
domestic battery or dating violence. The court finds probable cause. Bond is set in the amount of $1,500. No contact with the alleged victim.
Your Honor, this case requires Spanish
For no
interpreter.
return to the incident location.
I have no contact, no return. Yes. You'll have no contact with her. Have a good day.
This case required a Spanish interpreter.
And Elias,
Your Honor,
Your Honor, excuse me, Your Honor, this is the main jail. Mr. Martinez needs a Spanish interpreter. We have 3 Spanish cases.
okay, hang on. I think we'll have to wait for the Spanish interpreter.
No, I'm right here, Your Honor.
Oh, you're right there? Great.
I am. I've been
swear
here
to-
since you started.
You swear to interpret from English to Spanish and Spanish to English as best you can?
I do.
Okay, and as accurately as you can, obviously. Okay, then we have Mr. Renson Martinez.
Señor Renson Martínez.
And Mr. Martinez, you're charged with dating violence.
Señor Martínez, lo están acusando de violencia con una pareja.
And the court finds probable cause.
Les declaro que hay motivo fundado.
And the court sets bond the amount of $1,500.
La fianza es de $1,500.
You will have no contact with the alleged victim. That means you will not contact her directly, indirectly, or in any fashion.
No puede tener contacto con la víctima ni directa ni indirectamente.
And you will not return to that property.
Y no puede regresar a esa casa.
You will not come within 500 feet of that property.
No puede estar, tiene que mantener una distancia de 500 pies de esa propiedad.
Okay, thank you very much. Thank you, Madam Interpreter.
You're welcome, Your Honor.
Kenson Elias.
he's here, Judge.
Mr. Elias, you're charged with battery, domestic, court finds probable cause. Bond is set in the amount of $1,000. No contact with the alleged victim. Then we have Martinez,
This is another Spanish interpreter case.
Spanish interpreter. Thank you. I have no probable cause affidavit on this one.
Except for immigration hold, Your Honor.
The aggravated assault with intent to commit a felony and the battery are not for a magistrate. Is that correct?
Los dos cargos de agresión con agravantes y golpear no son para magistrado.
You have an immigration hold. It's no bond,
Tiene una orden de inmigración, por lo tanto no hay fianza.
and you'll be detained on the immigration hold for the immigration authorities.
Y lo van a detener por la orden de inmigración para las autoridades de inmigración.
For counts 1 and 2.
Oh, come, one moment, Madam Interpreter.
Yes, Your Honor.
I'll bring it over there.
That's okay, I got it.
And we need bond set for count 1 and 2 also.
Okay, no problem. Sir, on counts 1 and 2, you're also charged with aggravated assault.
El cargo 1 y 2 lo están acusando de agresión con agravantes.
All right, and the court on counts 1 and 2 sets bond in the amount of $1,500 count 1, $1,000 on count 2, no contact with the alleged victim.
Para el cargo 1 hay una fianza de $1,500, para el cargo 2, $1,000 y no puede tener contacto con la víctima.
Then we have Brandon Jackson. Thank you, Madam Interpreter. I think we're,
I understand that there's one more case, Your Honor.
well, I'm gonna have to work my way to it.
Absolutely. Don't worry, I'm right here.
Okay. We have Brandon Jackson up.
Yes, Your Honor.
Okay, Brandon Jackson, you're charged with false imprisonment, aggravated assault with a deadly weapon, domestic violence, and domestic battery by strangulation. The court finds probable cause. Bond is set in the amount of $1,000 on count one, $5,000 on count two, $1,000 on count three. No contact with the alleged victim, no return to the property, and the defendant will surrender all firearms in his possession to the sheriff's department within 24 hours of his release.
Also, Your Honor, the state acts that outside of does not possess any firearms, he possesses no weapons of any kind.
You're on mute. Fellas, make sure you guys are paying attention.
Counsel, I would grant your motion, and that the only problem is I don't know what that means. Since any object can be used as a weapon.
I meant specific, like, common weapons, knives.
But the problem is that they are in amongst household goods, etc.
Plasticware is the new thing now.
Well, no, I don't think we're gonna get to that point. And Andrew Hogan. You're charged with aggravated assault with a deadly weapon, domestic violence, battery, domestic violence, and false imprisonment. And the court finds probable cause. Bond is set in the amount of $1,500 on count one, $1,000 on count two, $1,000 on three. No contact with the alleged victim.
And Your Honor, in this case, we would be asking for a lower nominal bond based on his financial abilities at the moment.
Not at this time. Mr. Merritt?
Copy, Your Honor.
Okay, Mr. Merritt, you've got a battery charge, subsequent offense. They have a no bond hold, but I have no probable cause affidavit.
Your Honor, on this was downfiled to an aggravated battery. Originally, bond was set for $25,000 with the GPS. The state is now just asking for it to be set as a $5,000 bond, but leave the GPS in place.
Okay, now let me ask you this.
Yes, sir.
It was originally arrested for what?
Aggravated battery with a deadly weapon.
And now it is filed as a simple,
Felony battery. With prior or subsequent offenses. This is the second.
okay, but it's a simple battery as a felony because of subsequent offense.
Correct.
And you're asking for how much of a bond?
5,000 and
Okay.
the GPS remain in place.
Defense, you wish to be heard? That's okay.
Not here, Your Honor.
You have anything? Okay, 5,000 GPS. Have a good day. Court finds probable cause. All right, then we have Vincent Mosley.
Copy, Your Honor.
It's the same thing, down file. With bad charges.
Right. Charge 3 is an up file from a misdemeanor.
I have no probable cause affidavit.
So the original charge was.
Original charge was touch and strike battery, domestic violence for count 3, and for count 4, it was tampering in a misdemeanor proceeding. These are for the change of charges now with felony battery with prior conviction.
The bond was originally set for $2,500. For these previously, the state is asking for it to remain in place. And he was also placed on standard pretrial. So the state is asking for that to remain in place also.
But I mean, since there's no recitation of probable cause in this, matter, nor any indicia of how the police came into contact with Mr. Mosley, respectfully ask
Okay,
to
but
find
the
no
state
probable cause.
has already filed the charges, correct?
Yes, Your Honor.
All right, so that eliminates that issue. So we will set bond, and you're asking for bond and as 2,500 each count, correct?
Yes, Your Honor. That's the same bond that was found previously.
But that was on a different set of charges and a higher set of charges.
Correct. So
Bond is set in the amount of
everything-
$1,000 on count 3, $1,000 on count 4.
And standard pretrial judge, that's what we had previously.
No,
So the
just the-
pretrial requirement is being deleted for counts 3 and 4 only.
and no contact. Have a good day. Joseph Charles.
Your Honor, this was a refusal.
Good, I thought we were gonna,
Judge, this is Davika Carr on his behalf. This is a municipal ordinance charge. Good morning, Your Honor.
good morning. But he's refused. What do you want to do?
Your Honor, I would ask for it to be reset for tomorrow.
Reset for tomorrow.
Thank you.
Day. Thomas Thompson.
He's here, Judge.
Mr. Thompson, you're charged with driving while license suspended, second offense, and expired registration. Court finds probable cause bond is set in the amount of $100. And if I ROR you, will you show up in court?
Yes, Your Honor.
Okay, ROR. Have a good day. Louis Apuzzo.
He's here, Judge.
You got a capias for a theft, $100. Court finds probable cause. You want to plead no contest?
Yeah.
Time served. Waive. Juan Nieves.
No problem, Your Honor, no problem.
Okay, you got a municipal ordinance violation, open container. You want to plead no contest?
Yes, Judge, he does.
Okay, withhold and waive. Have a good day.
Thank you, Judge.
Oscar Lewis.
That was my other lawyer last.
Do we have Oscar Lewis?
Yes, Your Honor, he's present here.
Yes, it may do.
Main jail.
Mr. Lewis, you got trespassing, $100 bond, court finds probable cause. You want to plead no contest?
Yes, sir.
Time served, waive. Thomas Morris.
He's approaching, Judge. Main jail.
Morris, you got trespassing, $25 bond, court finds probable cause. You want to plead no contest? Time served, waive. George Dakiansky.
Main jail, Judge. He's approaching now.
Mr. Danieski. I'm trying to find out what the criminal mischief was. I don't have a PC sheet. Huh?
Capias, Judge.
I understand that.
You want to know why?
I want to know why.
Give me 1 second, Judge. Pull it over.
Steve, I don't need the printout. I just need you to tell me, what property did he supposedly damage and who did it belong to?
Because it has the blackout on PC. But it was a altercation with a business owner for refusing to let him enter. He locked him out the business, and then the defendant punched the upper glass pane of the.
Okay, so this was a private business.
Yes.
Okay, you've got two cases, the $250 each. Court finds probable cause. You need $500 bond to get out. Have a good day.
Your Honor, we would be requesting our ROR in this case.
Not at this time. You didn't show up the last. Jamal Picker Gills.
Your Honor, main jail, this is a refusal.
It's what?
He refused.
He refused to come to court.
Refused? Okay, reset. Then we have Bunsalel.
Yes, Your Honor, main jail.
Okay, Mr. Bunsalel, you got two traffic matters, driving with a suspended driver's license and off-lawful tag. Court finds probable cause. You got bonds in the amount of $2,100. I release you. Will you show up in court?
Yes, Your Honor.
Yeah, get your license straightened out. Go to court. You'll find out you can work it out pretty good. If you do that.
So that's our on counts 1 and 2.
I've got ROR on counts 1 and 2. Victor Nino Laguna. I didn't think you wanted him. Mr. Laguna, you've got a DUI, $500 bond, DUI, unlawful blood alcohol, $1,000 bond. Reckless driving, no bond required, and operating without a valid driver's license, no bond required. Total bond is $2,000. Court finds probable cause. Can you make the $2,000 bond?
Your Honor, he needs a Spanish interpreter.
Okay.
I'm here, Your Honor.
That was the one more, right?
Yes.
All right. Mr. Nino Laguna, you are charged with DUI.
Señor Nino Laguna, lo están acusando de manejar bajo la influencia del alcohol.
And there's a $500 bond.
Fianza de $500.
You're charged with DUI, breath alcohol over $1,000 bond.
$1,000 de fianza por manejar con un nivel de alcohol de más alto de 0.15.
And you have reckless driving and operating without a valid driver's license, no bond required.
Manejar con descuido y no tener licencia de conducir, no se requiere ahí fianza.
Total bond is $1,500.
La fianza completa es de $2,500.
And
De 1,500.
can you make the bond?
Your Honor, pardon me, is it $1,500 or $2,000? The total bond.
I believe it's 1,500, ma'am.
$1,500. ¿Puede usted pagar la fianza, señor? To make some phone calls.
And in this case, we would be requesting a phone order so that he has access to his phone.
Pedimos que tenga acceso a su teléfono.
Counsel, can your client make the bond?
¿Su cliente puede pagar la fianza?
Pero necesito llamar, pero no tengo el número.
¿Cómo?
No sé lo del número para llamar.
I don't know the number that I can call to.
He says he can post the bond. He just doesn't have access to be able to call the people who can post the bond for him.
I'll give him a call.
Le voy a dar permiso de que haga una llamada.
Lamont McNeil. Thank you, Madam Interpreter.
You're welcome, Your Honor.
Lamont McNeil, you're charged with loitering and prowling, $25 bond, court fines, probable cause. You want to plead no contest?
Yes.
Hold, wave. Have a good day.
Your Honor. May I make a probable cause argument for Mr. McNeil?
Was it with hold, wave? You want to do
Oh,
probably?
okay, yeah.
Okay.
I was thinking that.
Jason Matthews.
Your Honor, main jail, he refused to come up.
You refused? Okay. Reset him. Billy Hockaday.
No problem, Your Honor.
Okay, an ad charge of possession of a controlled substance without a prescription, $1,000 bond, court finds probable cause. This is count 6. It's added on to the other ones. Have a good day. We're Justin Robertson.
He waived his presence, Your Honor.
He what?
He's at the county. He waived his presence.
He waived his presence. Okay, he's got an out of.
He waived.
Somebody get him transferred when he's done here to Brevard County. All right, Mitchell O'Neill.
Your Honor, he's present.
I have no probable cause affidavit.
Hold on, Judge, let me see if I have it.
Wait a minute, I'm sorry. This is an ad charge?
It is, Judge.
Okay, so this is on the burglary, unoccupied, on a court finds probable cause. On the grand theft, the court finds no probable cause. On the grand theft, but probable cause as to petty theft. There is no amount to the value of the cables.
Your Honor, yes, there is. It says the cam lock generator cables were $1,200 a piece.
Where does it say that?
On page 2 of the PC at the very top.
Who?
Sorry,
Who says?
who says? Who says? The officer.
Yeah, but the officer does, they're not his.
I'm so sorry.
I'm sitting here and I'm thinking, jammed like $1,200. You're saying that that's legally sufficient?
I'm saying that you said that was the item stolen and the amount of those cables are $1,200. So
But we don't know how.
how
Do we have to?
to find PC? for-
Well, no,
Yes.
okay, turn around and I say, a police officer who's not his property, doesn't own the property, doesn't have possession of the property, says something is $1,200, how did he come up with that?
Well, Your Honor, the state will ask for 48 hours to perfect the PC. For that count, the grand theft count.
Okay, let me ask you this. All right. Burglary of an unoccupied home, such the court sets bond in the amount of $1,500. Court fines, although very, very minimally probable cause on the grand theft, bond is $1,000, total $2,500 bond. Can you make the $2,500 bond, sir?
It's a little bit dicey for me at this moment, but I can try.
Your Honor, I would ask if we could request a lower nominal
The
bond.
question is, and it's very simple, can he make the bond? Yes, no?
No.
Right.
He's also in custody on a Palm Beach hold. That's what count 1 is, which is a no bond hold. So essentially, to post his bond on this ad charge, which he's before you this morning, he would just be transferred over to Palm Beach. He will not be released.
Okay, I'm gonna leave it as is. Have a good day. William Robinson.
Main jail, Your Honor, he's approaching now.
Mr. Robinson, you're charged with grand theft auto, $1,000 bond, operating without a valid driver's license, and you got a parole violation. Parole violation is a no bond hold. You'll be detained, going before the parole board. Have a good day, sir. Nathaniel McGee. Mr. McGee, you're charged with possession of cocaine. The court finds probable cause. Bond is set in the amount of $1,000. Can you make a $1,000 bond?
No share option. No sir, Judge.
It's yes or no?
No, sir.
Okay.
Your Honor, no, he has, I'm looking at over 52 prior arrests for Mr. McGee.
How many?
Over 52.
Mr. McGee, you have a $1,000 bond. Have a good day. Paul Main.
Claim refused. Thank you.
Your Honor, that's, he named jail, he refused.
Okay. We'll reset them. Thank you. Calvin Atterbury.
Your Honor, main jail, he refused as well.
Just so you're aware, Mr. Atterbury, in addition to the petty theft, he's in custody on a no bond hold for violation of parole.
Right, he's got a parole violation. Call the parole board, turn him over to the parole board. Okay, Arthur McCleary.
So
McCleary?
just to confirm, Judge, for Atterbury, you're gonna go ahead and magistrate him absentia? Correct?
What's that? I'm sorry.
For Atterbury, we're gonna magistrate him absentia, correct? Because of the violation of parole.
Yes.
No longer- Okay, thank you. Judge.
Arthur McClory.
Yes, sir.
Hey, you're charged with driving with a suspended driver's license third time, $750 bond. That's a felony. Can you make the bond?
No, sir, I can.
Okay, and you've lived, how long have you lived in Broward County?
All my life, sir.
Okay, if I ROR you, will you show up in court?
Yes, sir.
Your Honor, can you please put him on standard pretrial?
No, I'm not gonna I was gonna ROR him. Now, sir, get your license straightened out and go to court. Make sure you show up in court. Have a good day. ROR. Shabata Martin,
No problem, Your Honor.
Yes, sir.
you're charged, sir, with petty theft, $750. It's a third offense. Grand theft auto, $1,000 bond. Driving while a suspended driver's license, habitual, $750 bond. Court finds probable cause. Can you make the bonds?
No, sir.
Pretrial release,
In addition to his lengthy history, he's not only violated.
Okay.
parole on a few times.
all right, well, you've got total bonds of $2,500. Have a good day.
Your Honor, the state asks for no victim contact and no return to the incident location.
No victim, no contact, no return. Alexander Farrell.
Yeah.
Farrell,
Your Honor, main jail, he refused.
we'll reset him. Troy Smith.
Main jail, he's approaching now.
Mr. Smith, you got possession of cannabis, a misdemeanor. The court will ROR you on that. Then we have possession of a weapon or ammo by a convicted felon, $1,000 bond. Carrying an electric device, $500 bond. And a traffic violation, no bond required. Total bond, $1,500. Have a good day. Court finds probable cause. Callie Chancey.
Main jail, he's approaching.
Mr. Chancey, you're charged with carrying concealed firearm, possession of a weapon or ammo by a convicted felon, and a traffic violation. Court finds probable cause. Bond is set amount of 1,000 count one, 1,000 two count two, total $2,000 bond. Have a good day.
Your Honor, we would be asking for either ROR or any alternative pretrial release. He has resided in Broward his entire life. He is employed, and he does have two dependents who do rely on him, Judge. So in light of this, we'll be asking for ROR or pretrial release.
I understand, but I'm leaving as it is. Charleston Michael,
Your Honor, main jail refused.
No, Your Honor, unfortunately, he's deaf, and we're gonna need a sign language interpreter for him. So I'm not sure if you're gonna have it for tomorrow or Monday.
okay, I'll reset them. Whichever day you have them.
Your Honor, I would request for Monday, just so I can reach out to my office so we have sufficient time to obtain this sign language interpreter.
So you want it Monday?
Monday, Judge.
Okay, you don't want it tomorrow, okay. Thank you. Paul Norlis,
Main jail, Your Honor, he refused.
reset them. David Moody. Mr. Moody, you got a VOP, no bond hold. You'll be detained going before Judge Pearlman. And your court date is 7/13 at 8:30 a.m.
And Your Honor, I would be requesting a mental health evaluation and any necessary.
Joel Tiller.
Have a seat back there.
Main jail, Your Honor, he's present.
Right back there.
Mr. Tiller, you're charged with 3 counts for battery. Court finds probable cause on all 3 counts.
The state is asking for 25,000 on each count, Your Honor, based on the nature of the charges and the defendant's criminal history. Which is, he was convicted of.
No, counsel, that's right, for prior history. Okay, and you're asking for 25,000 each count, is
Yes,
that
Your
correct? And no contact with the alleged victim, no return to the property?
Absolutely.
Okay, defense?
Your Honor, we would be asking for a more reasonable bond. He doesn't have the ability to post that at all. In this case, we'd be asking for something more nominal bond.
Judge, just
Yep.
so that the court is aware, Mr. Tiller is on loan from Florida State Prison,
Oh, lovely.
so he's back here for this case. So even if he were to post bond, Judge,
He would not get out. Correct. Okay. I'm gonna make it a no contact order. He's not going. $25,000 bond each count. Anthony Haney.
Thank you.
Main jail, Your Honor, he's approaching.
Got a petty theft, third or subsequent offense, $750 bond. Can you post the bond?
No, sir. No, sir.
No. Okay. How long you lived in Broward County?
8 years.
How long?
8 years since 2012.
Okay. Court will place him on pretrial release. Ricardo Gonzalez,
That's standard pretrial, Judge.
standard pretrial, yes.
Main jail, Your Honor, he's present.
Theft auto, court finds probable cause, $1,000 bond. Can you make the bond, sir?
Your Honor, Mr. Gonzalez is currently being supervised by pretrial services.
Oh,
2857 CF10A, aggravated battery with a deadly weapon. Based on this court's finding of probable cause and with act on this pretrial status doable.
so you're asking me to revoke his pretrial?
I am.
Okay. Okay, leave it there, I'll get
I'll
it.
leave it, yeah.
All right, And that is aggravated battery?
Yes, Your Honor, aggravated battery.
Okay, the court at this time on the grand theft auto bond is $1,000. Court finds probable cause on the aggravated battery. Court sets bond in the amount of, let me just take a look.
And Your Honor, he actually was also on an electronic monitor.
Okay. Court sets bond the amount of $5,000 in electronic monitoring. And okay,
Judge, will you be putting him on a monitor for the new law offense as well?
just for the aggravated battery again,
Okay, thank you, Judge.
and no contact, $5,000 bond. Larry Sorrells.
Main jail, Your Honor, he's approaching.
Mr. Sorrells is charged with grand theft auto, $1,000 bond, possession of cocaine, $1,000 bond, possession of codeine, $1,000 bond, and so total is $2,100 in bond. Can you make the bond?
One more time.
Excuse me? Is that a yes?
No, he cannot make it. He's resided in Broward for 14 years.
Okay, if you want to, I'll give you pre-trial, but pre-trial, for pre-trial, it's got a special condition. That condition is that you have a drug evaluation and you have drug counseling if recommended.
Sir, I'd like to order the
Your
number.
Honor, Mr. Sorrells is out on a pending felony right now.
It's the felony.
An armed burglary, possession of firearm by conviction.
Okay, you got $3,000 in bond, sir. Have a good day. Thank you. And then we got Dwayne Simmons.
He refused, he has probation. So
Your Honor, main jail, he refused.
Okay, reset him. Now we have Pierre Sims.
Present, Judge.
Okay, Mr. Sims starts with false information to law enforcement officer, $100 bond, possession of an ammo or weapon by convicted felon, count 2, $1,000 bond, possession of a weapon or ammo by a convicted felon, $1,000 bond, and fictitious driver's license, $25 bond. Total bond, $2,125. Court finds probable cause, all counts.
Post that, but this the thing.
Rolando Rio Perez.
Your Honor,
Go ahead.
he has access to his phone.
Yes, you can make a phone call.
Number, so I need to get my on my cell phone.
Yes, he needs, yes, we would be requesting a phone order so that he has access to
But
his
if I
cell
were you
phone.
seized it.
You first brought everything in your property.
No, they didn't. They didn't bring it last night. I checked.
Your Honor, if we can, yeah, we would be requesting a phone order just in case he does have the phone within the possession of BSO.
I notified the Viper unit last night. I told them my situation. I told them that I need to get my phone contacts, and they let me get my phone contacts, and they wrote them down. They said it's going to go with you to the main jail. But when I got here last night, they said the paper wasn't here. So they basically lied to me. They threw the paper. I don't know what they did with the paper, but I need my contact. I can't.
Sir, do you need to make an additional phone call?
I don't know anybody's phone number, so that's why I'm telling you I need to get it out of my cell. I don't know anybody's number. The only person's number that I know is my mother. My mother's not gonna come find me out. My mother's not gonna. She's not gonna tell nobody else to come find me out. I gotta call my friends.
Sir, you're rambling on. My question is, you're now telling me you need your cell phone?
I need to get my contacts. Yes, I need my contacts.
All right, well, let him get his contact off the cell phone. I'll grant that.
Thank you.
You can use the cell phone. You can make a call. You can download the contact from it. whether they have some rule about cell phone use or, but have a good day. Then we have Ronaldo Rio Perez.
No problem, Your Honor. Hello?
Mr. Perez, you're charged with trespassing and resisting with violence. Court finds probable cause. Bond is set in the amount of $100 on count one, $1,000 on count two, $1,100 in bond. Have a good day, sir.
Okay.
Then we have Marlon LaRose.
Your Honor, main jail, he bonded out.
Bonded, thank you. Daniel Goodling.
Main jail, Your Honor, he's present.
Charged with petty theft, third or subsequent offense, $750 bond. Court finds probable cause. $750 bond.
I don't have it.
All right. If you can't make it, how long you've lived in Broward County?
On and off since 1999, full-time since 11.
Couldn't understand them.
Oh, I started in 1999. I came back in 2011 with full-time. Part-time since 99, full-time since 2011.
Pre-trial, will you take them?
I have no record on him, so I couldn't say if the court orders me to take him.
Okay, well, make it conditional. If he can qualify for pre-trial,
We're gonna do pending verification then?
pending verification.
Thank you.
Your Honor, the state asked for a no return to the Home Depot on.
No return to Home Depot. Adam DiLorenzo. Adam DiLorenzo. Mr. DiLorenzo, petty theft. Court finds probable cause, subsequent third or subsequent offense, $750 bond. Can you make the $750 bond?
Yes, sir.
No, Your Honor, he can't.
Okay, court, trial if he qualifies.
We'll also have pending verification of that one.
Pending verification, correct.
Your Honor, the state is asking for the same no return.
No return. Nicholas Bradow.
Your Honor, main jail, he refused.
Okay,
Just so that the court is aware, Judge, Mr. Brandow refused on yesterday as well.
now reset him. Maybe he'll get tired and come out. Eddie Butler.
Main jail, Your Honor, he's present.
Mr. Butler, you're charged with petty theft, $750 bond because it's a third or subsequent offense. Grand theft auto, $1,000 bond. Court finds probable cause. Can you make the bond $1,750?
Yes, sir.
All right, pre-trial release. Pending verification. James Hilton.
Your Honor, main jail, he refused.
All right, Mr. Hilton has got a violation, possession of heroin, $1,000 bond, in violation of probation. He's set for hearing on the 13th of July. Reset him. He may be under.
We're gonna reset Mr. Hilton.
What's that?
We're resetting Mr. Hilton, Judge.
How do I get around resetting him?
Well, he has a.
It's got a VOP. They're gonna take him over on that.
Correct, but are you gonna reset him to come back before for the count one or?
Yeah, for the count one.
Okay.
Timothy Anderson.
Your Honor.
Your Honor, main jail, he's present.
Mr. Anderson, you've got a $25 capias on a municipal ordinance, but you've got warrants on pre-trial, all felonies, no bond. I can't offer you a plea or do anything with the maybe I can. Oh, no, I can't.
We really appreciated the opportunity.
Because of the pending violation of the pretrial release. So you've got no bond holds. You'll be taken before, I guess is it Judge Navarro? Or, well, you'll be taken before whoever they assigned to the case at this time. Now we have James Peterson.
Judge, he was magistrated yesterday in absentia, so he is a deletion from the docket.
Okay. You leave him from the docket. Then we have Shamari Brown.
Bonded out. Your Honor, main jail, he bonded out.
Bonded, thank you. Then we have James Bowie.
Main jail, Your Honor, he's present.
Mr. Bowie, you're charged with possession of methamphetamine, $1,000 bond. You have a trespass, no bond required, $1,000 bond. Can you make the bond?
No. No, Your Honor.
Okay, court will place him on pretrial release if you agreed to have a drug evaluation and counseling if it's recommended.
This is Mr. Bowie.
This is Mr. Bowie.
He also has a pending case, 15847, for possession of methamphetamine, resisting officer without violence, and trespass.
And is he on pretrial for that?
No, he's not. He posted his bond.
He posted his bond?
Yes, sir.
Okay. I'll put him on pretrial. It's saying
Count one and count two, Judge, or just count one?
count one, count two is not a bond required. I don't think. Yeah, no bond required on the trespass. If you want to, RR to make it clear. Okay, Charles Howard.
Your Honor, before you address this case, may I approach with the arrest warrant?
Yes, that would be very nice.
Your Honor, this is Mr. Howard at the main jail.
I'm waiting for the provided with the documents for the probable cause. Hey, you got him?
Yes.
So don't let him, I've got to read them first.
I'm sorry, stop me before you.
But I'll give them to you.
It's on this page, this page here.
We don't have copying machines in this world.
I think it reads, it's not on the computer.
Ah. Okay, you may have them.
Judge, I'm the Spanish interpreter. May I be excused?
Yes, you may, ma'am.
Thank you, Your Honor.
Very
Goodbye.
much.
Thank you.
Bye-bye. Okay. Court on Charles Howard.
Yes, Your Honor, he's present.
Count one is attempted first degree murder. Count two, attempted murder, second degree, and throwing or shooting a missile into a dwelling or building. State,
Yes.
you want to be heard?
Yes, Your Honor. First, to let the court know, originally, this was brought before the court originally, but the two counts originally of first degree attempted murder. The court at that time found proof evident presumption great for that, for those counts. The state has filed the actual information charging the defendant with the count one as first degree attempted murder. It's just a technical change of charge. So the state is asking for you to adopt that same finding or proof evident presumption grade.
Okay, but what about count two?
Yes, Your Honor. The state is asking for you to set bond in the amount of $250,000, and for count 3 an amount of $25,000.
But you're already asking for proof evident presumption great, so no bond on count 1.
Well, technically, it was already granted, we're just.
Well, I understand that part of it, too. Counsel, I understand that part of it. Okay, I just don't know why you're asking for, what was it on number count 2?
For the second degree attempted murder, $250,000.
Defense, go ahead.
Your Honor, since, well, to begin, since this is, you know, a serious charge and a capital charge and a man's life and time on earth, depends on your finding of proof evident presumption great. I would ask that an independent determination be made, and not done so by the finding of another judge. Second of all, the facts of this case state that, well, first, if it is only based off of one person's MJ.
Only one.
Only one person who.
That was
saying
sarcasm, counsel.
That Mr. Howard had shot at them. The other person was sleeping, and the other person was in their room when this all occurred.
But I believe the woman ran in fear and said that she was afraid and thought he was shooting at her at the time.
Right, first it's MJ who actually knows the defendant. And when he.
No, that's okay, counsel. You don't have to interrupt me.
Okay, I'm sorry, I apologize, Your Honor. I thought you took a breath, I apologize. I don't mean any disrespect to the court.
Counsel?
Well, I mean, I'll just fall back on what I stated before. I mean,
I got you.
One person was on the couch sleeping, and then he was awoken by the shot, but he had lost consciousness. So I mean, who knows who that could have been. Second of all, the other person stated that they were in their room, and actually one of the persons involved wasn't had actually declined to prosecute.
But that's not the one that's in the second degree.
I'm sorry.
That's the victim of the second degree, is not the one who declined to prosecute.
Right, correct.
I'm on the same page with you, counsel. I understand what you're saying.
Yeah, I just don't, or excuse me,
Okay.
but when it boils down to it, it is the word of MJ who is saying this, and the only other two people that are stated to have been there did not positively state that it was Mr. Howard, and yeah, that's my.
Well, I think that's been taken out of our hands, because right now these cases are now filed, I'm understanding.
Correct, yeah.
Okay, so on count 1, the attempted murder count, first degree, the court does not change the findings of the prior judge, and based upon it, it's already been found to be proof evident presumption great, and a no bond. The court will retain the no bond on that one. On count 2, it's a change of charge, and the court will set bond in the amount of $150,000. And then on count 2, count 3, the court will set bond in the amount of $25,000 and no contact. And have a good day.
No contact with the victim and witnesses.
Well, no contact as to the alleged victims whose names appear in the probable cause affidavit, but I'm unable to enter an order as to all witnesses. I don't know who they would be.
I understand. Thank you.
Thank you. I believe that concludes the docket.
Yes, sir.
Thank you.
And I thank you all. Now, before the state and defense, before you guys get away, would you take one piece of paper, print your name and your office phone number so I have it for my records?
Yes, ma'am.
Okay, and hang on, I'll be right with you.